Imagine you're a green card holder. You're planning on vacation. You take your family. You travel abroad and you're coming back to United States. Now you don't have any criminal convictions. You just have pending charges, allegations against you. You come to United States at the port of entry. CBP officers may stop you, sending you to secondary inspection for review. You may wait there for hours, and your future ability to enter the United States feels uncertain. Well, that is not fiction. This is a recent Supreme Court case that may make international travel for green card holders more complicated when legal matters are pending in general. In this video, I'm going to break down this new case called the recent ruling, what it means, who may be affected, and what you should consider if you're a green card holder planning to travel outside the United States and you have pending charges now. All the updates, all this information in one video here. Here is what this case is about, briefly. And we need to start with the baseline rule. If you're a green card holder, typically when you travel outside the United States and when you come back, you're not generally treated as someone entering for the first time again. You're not paroled into the United States. You're entering as a green card holder with all the rights of a green card holder. That is the standard baseline rule. But Congress created several exceptions to this rule under Immigration and Nationality Act, Section 101A13. And what that means is that if green card holder committed crimes involving moral turpitude, controlled substances, or multiple convictions, then they may be treated differently under immigration rules. And the usual debate was always about how to treat someone with those convictions in their background, when they are green card holders, once they enter the United States after travel abroad. Are we treating them as green card holders, or as a first-time admission, parole, or other situations that could put them in trouble and risk their green card status? And this was the central issue in the recent Lao case, the Supreme Court decision itself. So what happened in this case? Mr. Lao was a green card holder, and he had a pending charge involving trademark counterfeiting. He was accused of falsifying some documents connected to the trademark, and he was still waiting for his trial then. He wasn't convicted yet. While he was waiting for his trial, he traveled abroad. When he came back, the CBP officer determined that he had committed a moral turpitude offense abroad. As a result, he was treated not as a green card holder, but as someone seeking admission for the first time at the border. Instead of admitting him as a green card holder, they paroled him in so he could handle his criminal matter first, right? So, they didn't block him from entering, but they let him in on parole. Later on, he pleaded guilty to the single count of counterfeit documents. Then later, DHS put him in removal proceedings. They said he was inadmissible because of only one count of crime involving moral turpitude. Now, if he had been admitted as a green card holder, you would need 2 convictions to be deported. And obviously, the standard is higher, but he wasn't covered by that protection. The immigration judge in his case ordered him to be removed. The Board of Immigration Appeals later upheld that judge's decision, but the Second Court of Appeals stepped in and said the Customs and Border Patrol agents needed clear and convincing evidence that Mr. Lao had actually committed a crime at the time of entry, before they could even treat him as an arriving alien, as they had done in his case previously. Without that high burden of proof, they should have admitted him as a green card holder. And if he had been admitted as a green card holder, one conviction for crime involving moral turpitude would not have been enough to remove him. He should have received 2 of them. Do you see what I'm saying? So because he was admitted as an arriving alien, his level of protection was so low that he was removed. But if they let him in as a green card holder, because he wasn't convicted yet, he would not have been removed. So the Supreme Court in this case said they do not need clear and convincing evidence at the border in order to allow a green card holder to enter, even when there are only allegations and not a full conviction. So as a result, this is bad news for green card holders overall. So what can I suggest now to clients who are green card holders who are planning to travel and have allegations of any criminal charges against them currently? Number 1. If you have an open criminal matter that could later qualify as a crime involving moral turpitude, like fraud, misrepresentation, or even tax evasion, you need to be careful about international travel right now in some situations. Even if you're not convicted yet, Once your case is resolved or you receive a lesser charge, you can travel, and even then you should carry the right documents showing how the matter was resolved before any trip abroad. Number 2. Keep records of everything. If you go to secondary inspection and they give you anything to sign, make sure you keep all the records once you enter the United States, because sometimes the wrong classification at entry could create serious consequences if you're later convicted. Just like what happened to Mr. Lao in this example. Remember, CBP officers are not criminal attorneys. They are not judges, but they still have broad discretion there. So, if you have any issues with the law and you have a green card, make sure you speak with an immigration attorney before traveling. Right now, in our office, we have updated our intake forms to ask green card holders if they have pending charges, not just convictions today. Before, we only asked whether someone had been convicted. Now, I want to know about any of your pending charges, whether they are criminal or not. So then we can assess and decide if you have a risk to travel outside of the United States. Now remember, the stakes of the game are higher today. It doesn't mean that every green card holder is at risk. Obviously, if you don't have any issues with the law, how minor they are doesn't matter. You're fine. But if you do have anything, even a possible DUI, even something that could result in a conviction, it is better to consult an attorney before traveling rather than having a surprise when you enter into the United States. If you have any questions about this new rule, let me know in the comments. Drop a comment if you're planning to travel and you're a green card holder. If you're planning to travel and you're a green card holder, book a consultation to understand the risks and what to do if CBP officers ask questions at the border before you return home, and plan ahead carefully. Send me a message. The WhatsApp number is on the screen right now. It is summertime. People want to travel, but some people unfortunately run into trouble. Make sure you make those arrangements. Make sure you check with an attorney before you travel. Otherwise, have a beautiful summer vacation and enjoy your trips. And I'll see you at our next video.